An Amnesty Committee hearing is a legal process, but it is not a court of law. The hordes of attorneys and advocates who have now descended upon this process to represent any kind of applicant or implied person or vaguely mentioned police general seem to disregard this fact. Most of the time at this week's hearing was spent on endless arguing and bickering among lawyers and advocates, most of them paid by the taxpayer.
For record purposes, my name is LJ Alfissa.
I only act for General Smith, so I can only speak on his behalf.
So presently we act for 81 applicants.
I want to place this simply on record. I want to place on record now. I want to place that on record now. But what I want to do is I want to place this on record.
That is correct, and yes. I certainly would do so. My learned friend overlooked to mention that he'd given a similar undertaking.
No, right now I'm not interested in that debate. I want to know whether that can be done as soon as possible.
I think that the distinction is more apparent than real.
My submission is that also entails the right of the applicant's representatives to cross-examine.
If there was a substantial dispute of fact, he would not be entitled to put up an affidavit from his client.
Those persons aren't here. We cannot cross-examine them, but he has the right to cross-examine the applicant. You will have the right also to cross-examine him should the facts be disputed.
We will have to be led by you at that stage.
Let's see whether that kind of problem arises.
W for Wagner 1, 2, 3, and 4.
Exhibit P.
Could I just raise one very quick issue with you?
All right.
Totally happy.
I do not have that information.
And I don't think that any of us can pretend that we've applied our minds at interpreting every section or every phrase in the Act.
Is that not a fact?
We rely on your good judgment.
Yes. We certainly don't want to get involved in an argument about it with my learned friend.
No, Mr. Chairman, I still don't understand